Michigan versus Frank Michaud. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the threat, duress, and coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple of preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of some things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the Sixth Amendment grants me the right to know the nature and the cause of the action. I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Once again, we find ourselves in the ever-chaotic courtroom of Judge Green, who has already endured Frank Michaud's bizarre legal theatrics in multiple hearings. The moment she opens the session, the atmosphere feels heavy with déjà vu. The same nonsense about jurisdiction and sovereignty that has plagued every previous appearance. Frank begins the proceeding with his rehearsed sovereign citizen jargon, identifying himself as the beneficiary of his own estate and appointing the judge as trustee. Judge Green maintains her composure, recognizing immediately that she's about to ride another wave of pseudo-legal gibberish. It's a masterclass in judicial patience as she politely tries to establish basic order in a courtroom where logic has long since fled.
Civil or criminal. And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.740124 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a range rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempt to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter, the court's question back to you, sir, is: are you prepared to proceed with the exam in this matter?
no.
Charges are read: felon in possession of a firearm, carrying a concealed weapon, and felony firearm. Judge Green gives Frank every opportunity to participate like a rational adult. Instead, he interrupts her with claims that he needs to better understand the jurisdiction. The prosecutor, Mr. Mohammed, can barely hide his frustration, reminding the court that this exact issue has been ruled on several times. Yet, Judge Green remains calm and lets Frank make his record. Knowing full well that record will be filled with meaningless constitutional citations, and misquoted legal codes. It's almost impressive how she balances assertiveness with restraint, refusing to let his delusions derail the process entirely.
The exam.
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as the trustee.
The hearing soon descends into a familiar spiral. The "what jurisdiction is this court under" routine. Frank insists the court lacks authority, bouncing between claims of admiralty, maritime, and common law, as though saying enough buzzwords might somehow erase the charges. Judge Green explains, for what must be the fifth time, that this is a criminal court in the state of Michigan. Frank, however, refuses to accept reality, fixated on his fictional distinction between civil and commercial jurisdictions. The absurdity of it all becomes almost comedic, especially when he demands to know whether the case is criminal or criminal civil, a phrase that perfectly sums up his confusion.
And if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the court's, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we're about to proceed, so you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So,
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you,
okay,
but
so
I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right, but you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
I just want to ask you, far as, hold on one second. I want to read this for you too.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party in interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
it says that possession of a deadly weapon is a commercial crime. So I need to have a better understanding if this is a commercial crime. You said this is a crime and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser. And it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you're telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what?
At this point, Judge Green lays everything out in plain English. The charges, the dates, the prior convictions, the habitual offender notice, everything. She spells out exactly what he's being accused of and why this is a criminal matter under Michigan law. Still, Frank refuses to engage, insisting the court hasn't stated its jurisdiction for the record. The irony is painful. He's been told repeatedly that it's the 134th District Court, but he's so deep in his delusion that words no longer matter. Watching him argue is like watching someone try to debate gravity. The more he insists it's not real, the harder reality slams him back into his seat.
Now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says, the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27, Code of Federal Regulations, 27-7211, all crimes are commercial. So I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threaten the rest of her.
When Judge Green gives him 3 clear options, proceed, waive, or adjourn, Frank panics. Instead of answering, he claims he's acting under threat, duress, and coercion. It's a phrase straight out of the Sovereign Citizen Playbook, meant to nullify any agreement he might make. He even tries to appoint his lawyer, Mr. Sullivan, as his trustee, as though renaming legal terms magically changes their meaning. Judge Green corrects him firmly. He's your lawyer, not your trustee. Yet what's fascinating is how methodical she remains, never once losing her professionalism despite being forced to decode a stream of
Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any condition.
Voice Frank's paranoia kicks into overdrive as he accuses the judge of threatening him with contempt for simply asking questions. Judge Green, ever patient, clarifies she never said that, but he's already locked into his victim narrative. He insists that just holding the hearing is a form of threat, because it pressures him to comply. This is classic sovereign logic, twisting every act of procedure into an act of oppression. The comedy is that while Frank is arguing about theoretical threats, the real threat to his freedom is his refusal to cooperate in an actual criminal case. The irony couldn't be louder if the court